Hello, I'm Dave Stiegel. I'm a shareholder at Lawton and Cates. And in today's video, we're going to talk about whether you can sue your employer for a work-related injury. As always, if there's anything I talk about in this video that you have a question on or want to respond to, feel free to leave a comment. I'll be more than happy to respond to you as soon as I can. Otherwise, you can always contact me directly. My website, including all my contact information, phone number, or email, located on the description to this video and on this channel. Love to hear from you, so feel free to contact me anytime. Today's topic, can you sue your employer, comes from an actual conversation that I had earlier today with a potential client. He was hurt at work, he believes it's the fault of his employer, and is very upset that his bills aren't being paid and he's in a lot of pain. And he asked me, in fact, he told me, hey Dave, I really want to sue my employer. How do I do that? So I'll give you a synopsis of what I told him without betraying any of client confidentiality. So here's the deal. The short answer is he can't sue his employer. If you're hurt at work in Wisconsin, you are stuck, for better or worse, with the work comp system. You may hear it referred to as your exclusive legal remedy. So what that means is the work comp system in Wisconsin is it's called a grand bargain, kind of a catchy phrase, but here's the deal. A long time ago, before work comp, if you got hurt at work, you had to sue your employer and you were subject to rules around fault. So unless you could establish that your injury was your employer's fault in a courtroom, those injured workers, you would lose and get no benefits. Slowly but surely, the tide started to change, and employees started getting big jury verdicts in response to largely despicable employer practices that led to unsafe conditions and a lot of unnecessary injuries. So these companies were becoming more and more fearful of these large verdicts for pain and suffering to injured workers. So in the 1970s, this grand bargain was hatched. And it's a compromise. It's an insurance system. You have to remember that, between employees and employers in our state. So on the employee side, it's a no-fault system. So whether your injury was produced by a true accident through no one's fault, or whether it was mainly your fault, or whether it was someone else's fault at work, it's a no-fault system, and you can recover without having to worry about proving fault in court like you would have to under the old days before work comp. So the trade-off for injured workers, though, is there is no allotment for pain and suffering like you could recover in a civil claim in a courtroom. This is a big difference. The value of a claim, if you and I had the same injury but I was hurt at work and you were not, your ability to make a claim for pain and suffering in the vast majority of time would mean you would be able to obtain perhaps dramatically more money than I would, just given that difference in your ability to claim pain and suffering. So the downside of this bargain is, on the employee side, there is no allotment for pain and suffering. And pain and suffering, let's be real, is the main stuff that you're going through, the pain related to your injury. What the employers receive is protection from large jury verdicts for pain and suffering. They get much more managed risk. They know what an injury will cost them to the penny once they know the extent of your injury and whether it's permanent. They can look on a fixed table and have a really good idea, where before they were subject to the whim of a jury. So this trade-off works better depending on how you were hurt, frankly. If you're in the classification of workers that was hurt by a mechanism that wasn't attributable to anyone's fault necessarily, if it was a true accident, then work comp is a good system for you, because you will recover benefits that you wouldn't have recovered had you been left with only recourse of having to sue in court to get benefits. However, if you were hurt in situations where it was clearly your employer's fault, or it was clearly a co-worker's fault, there's no way around it. The fact that you cannot make a claim for pain and suffering is a major minus or disadvantage of the work comp system. There are exceptions. There are times it's called a third-party complaint, where if you're hurt at work, you can sue somebody else besides your employer, assuming, of course, that you can establish negligence or some other cause of action. A third-party complaint is outside the scope of this particular video. I'll probably address it in a future video. But for now, general rule is if you're hurt at work, you can't sue your employer, okay? All the more reason that you need to really maximize your work comp benefits. In my opinion, no one ever gets rich off work comp. It's not that kind of system. Remember, it's an insurance system. So you got to do everything you can to maximize every dime you can. I hope that's somewhat helpful for you. Again, if you have questions about your specific case, I welcome you to have me tell you exactly and precisely what my recommendations would be to you, given your specific situation. You don't want to leave those types of comments or questions in a public forum, so I'd encourage you to contact me directly. Okay, I hope that helps you some. Again, my name is Dave from Lawton & Cates. I appreciate your time and attention, and I look forward to speaking with you again in the future. Bye-bye.